Hi, everyone. I'm Kim Straker, and we're happy to be hosting part three of our Return to Work series. I see that some of you here attended our first two sessions, so welcome back. And welcome to those of you joining us for the first time virtually. I'd like to introduce you to my colleagues, Victoria Vitarelli and Lisa Savagian. Victoria is going to kick it off today by discussing important steps to take when returning employees from furlough. She'll also discuss issues for you to think about if you have to extend furlough for employees. Then we're going to turn it over to Lisa, and she's going to discuss COVID-19 liability waivers. We've received many inquiries on whether these are advisable and enforceable. Lisa will also discuss screening employees in the workplace, and finally, the different theories of potential liability and exposure on COVID-related claims. So we have lots of interesting topics for today. When we host these events in person, we encourage you to interject with questions throughout the presentations. However, virtually, we feel that it works better if you hold your questions until the end of each subtopic. Both Victoria and Lisa will pause when they finish their topics, and they'll allow time for you to ask questions. Or if you'd rather submit your questions in writing in the chat box, I'll be monitoring that, and I'll make sure that we address your questions. And if for some reason we can't get to every question live here today, we will contact you individually after the event to answer your question. Hopefully you all received by email a handout outlining today's discussion. We just thought it would be helpful for you to have this as a roadmap of our discussion today. You'll also see that we'll be sharing it on this screen here once Victoria starts with her presentation. So before we begin, we just ask that you please put yourselves on mute to minimize the background noise. And also, one last thing is we wanted to inform you that we are going to be recording this event, and this is so that we can send it out to clients who were unable to attend today. With that, I will turn it over to Victoria, and thanks.
Thanks, Kim. Like Kim said, I'll be talking about furloughs and returning employees from furlough and also extending furloughs and the implications that come with each of these. So basically, we want to start with the fact that furloughs have been around for a while, but with COVID, they became much more well known. And so a furlough is often used as a cost-saving measure or an alternative for an employee termination. And a lot of employers chose to go this route when COVID really struck and employers decided that they needed to take on this cost-saving measure. So now, as the months have progressed, some employers are deciding that they're going to return some individuals from furlough and would like to know the measures that they should take in doing so. So one of the concepts to understand and to also consider is the decision of who will return to the workforce. And this is crucial when not all of the individuals who are furloughed will be returning and only some of them will be. And the considerations of who to return to the workforce has some legal implications. And that is so because an employer may be faced with a discrimination claim or a disparate impact or disparate treatment claim if the individuals who they choose may believe that they were a part of a protected class or that they were targeted and not being returned to furlough. So this, for example, if an employer decides that it's going to return some of its employees and it happens that it is returning employees that are all male or all white or all above or below the age of 40, it may do so not purposefully, but in determining who to looking at the employees that are available, this may be an implication that is is not purposeful. And this is something that employers really should consider because they want to avoid that discrimination or disparate treatment or disparate impact claim. So there are some considerations that an employer should take in deciding who to return back. And the best thing to do is consider developing a business plan for bringing back certain employees. So this should be written so that there's something concrete to go back to. And in this writing, it should include an explanation of the business conditions. So where the employer is at financially and the considerations that they need in continuing their business. The number of employees necessary for the continued operations. If the employer is in multiple locations, consider which locations are seeing an increase in business. This is crucial also because certain areas of the country are seeing an uptick in business where previously they saw a decrease in business and vice versa. So this is really important to consider at the time in which the employer is considering bringing back individuals from furlough. And then also particular qualifications or skills that are needed from the employee. So that the employer is able to determine whether it needs a certain employer, just say for a restaurant, a restaurant may need another server. The employer is not going to hire a cashier. So that's another consideration of what type of job are you looking to fill. And also, particular for COVID, is where work is permitted based on local order. So is the employer able to function as it would like in certain locations? This information will assist the employer in deciding who will be offered the opportunity to return to work. And also a statistical analysis can be run. It can be as simple as on an Excel spreadsheet, but determining who the employees who are furloughed, determining the qualifications, and all the different aspects that I just ran through to make sure that there's no disproportionate impact on members of a protected class, and being able to be sure that an employer can do its best to try to avoid any type of discrimination claim or disparate impact or disparate treatment claim. This information can also be useful if, like mentioned previous, if an employer is not bringing back its entire workforce and is only bringing back some people, this would be helpful for an employer to answer the questions of employees who have not been brought back for furlough. So the situation would be the employer decides it's going to bring back X employees, but not Y employees. And the Y employees did find out that X will be returning. And the Y employees inquire as to whether why Y employees have not been brought back. This is something that an employer can turn to and explain that it was depending on the demand, where there was a need, the uptick in business, the service in certain areas. So this is really helpful for an employer to pull right out and have an explanation, easy go-to to explain to an employee why he or she is not being returned at that time for furlough. The next step then is, of course, informing the employees of their return to work. So this would be best practice as in a letter, advising the employee of their return to work date. And if it's going to be a tentative date, of course, include that information as well. Especially with what's going on with COVID and how it is an evolving situation, it's prudent to note that the employer is constantly monitoring the CDC and the guidelines and local law so that the employee can be aware of the fact that circumstances may change. Providing the employee with as much information as possible on that front is a best practice. And also to advise of the safety protocols and safety measures that are in place if the employee would be returning to the work site and not be working remotely. This also would go into the fact of an employee completing a return to work survey. So this would be if an employee returning to the work site or the office, so that an employer can learn of the employee's restrictions for certain days, for child's care, for health reasons. And so that at the forefront, the employer is well aware of what the employee is capable or incapable of, based on the way that the world has been changing. And also with September here today, with schools, with children's schools, and knowing and with daycare. So there are a lot of considerations, especially now as the school year seems to be starting in most areas. And then there's also providing the returned employee with an acknowledgement, so that they acknowledge that they are aware of the protocols that are occurring in the workplace, that the company that they've received the information from the company about all returning employees to maintain a safe and healthy environment, that the employee agrees to abide by these safety protocols. Questions that you may be receiving when you go to a doctor's office, or even certain facilities. Have you been tested? Have you tested positive? If you haven't been tested, are you do you have any symptoms? And letting the employee be aware of what is expected in terms of reporting such symptoms or circumstances that may arise. So that is a quick overview of returning furloughed employees to the workforce. And the next topic here would be extending furloughs. So extending furloughs, at this time, because we're in September, we are at 6 months out since really it's been the hardest of COVID. There is the Federal WARN Act that should be in a consideration for an employer. So the Federal WARN Act applies to businesses with 100 or more full-time workers, and or businesses that employ 100 or more workers who work at least a combined of 4,000 hours per week. The law is rather specific, and what WARN requires is that an employee be given notice of an event in which the event affects the employment. So this would be pre-COVID. It was a plant closing or a mass layoff, and there's specifics in there of what would trigger a WARN notice. But we're going to look into this as how it applies to furloughs. So the federal WARN and other states have mini WARNs, and I'm going to talk briefly about New York's, apply if an employee suffers an employment loss. An employment loss occurs when an employee must be discharged, laid off for at least 6 months, or have his or her hours reduced by at least 50% in each month of a 6-month period. As a result, federal WARN and in most states, the temporary layoffs, which are essentially furloughs in a sense, of less than 6 months duration will not trigger any notice obligation. So if an employee is only being furloughed for less than 6 months, this is not a consideration. But because we're in September, we're at that 6-month mark where a lot of employers decided to make changes for cost-saving measures. This is a consideration that an employer should take. Now, employers are relieved, however, from the 60 days notice, advance notice under federal WARN if there's unforeseeable business circumstances. And an unforeseeable business circumstance as caused by an employee's sudden, dramatic, and unexpected action or condition outside the employer's control. Cue COVID. So, given these provisions, employers should ensure that any communications to employees regarding furloughs should state that the employer is taking the action because of the conditions related to furlough. So, the 60-day notice has not been suspended. In the federal notice has not been suspended, but there is a condition wherein if there is an unforeseeable business circumstance, the 60 days is not strictly implicated. So a temporary layoff that lasts longer than 6 months is considered an employment loss. And the temporary layoff or furlough without notice that is initially expected to last 6 months or less, but later is extended to the 6 months, may violate the act unless these two things occur. The extension is due to business circumstances, including the unforeseeable changes, not reasonably foreseeable at the time of the initial layoff, and notice is given when it becomes reasonably foreseeable that the extension is required. So that means that you should still provide notice to your employees as soon as possible, and be sure to provide that notice and explain the conditions related to COVID. For New York is a little bit different. It's more restrictive in terms of what it considers to be an employment loss. It applies to a greater number of employers, businesses with 50 or more, as opposed to 100, and also it also recognizes that there is that unforeseeable business condition change that can provide an employer with giving an employee less notice than the 60 days. And lastly, just going to touch on benefits that occur with furlough. So most employers have continued to provide benefits during furlough to their employees in different extents. We advise that you are guided by the plan, the benefits plan, any CBA that if there is any, and also that the initial letter that was given to the employee. Did your company tell the employee, we are going to provide you with benefits through a certain date of your furlough, or did you advise that through your entire furlough benefits will be covered? Those are some considerations before deciding whether or not you're going to continue giving benefits. Now, providing benefits during furlough is not a requirement, and an employer should consider whether or not its business can sustain providing benefits to furloughed employees. If the company would like to continue providing benefits, it can, but it doesn't have to. And an employer can give COBRA notice. We've been asked what is the benefit or the greatest consideration in either extending a furlough or just laying off an employee. And the benefit really is employment relations and also providing that the employees with benefits through the furlough. So keeping morale up and positive and to the outcome and hoping that an employee will be brought back from furlough is the benefit. Also, if an employer can bring back the employee later in time, the employer will not have to go through the new hiring process all over again. So that's a quick overview. There's a lot covered, but I will welcome any questions based on furlough, extending furlough, benefits in furlough, but thank you.
I have a question.
Yes.
Can you hear me?
Yes.
So I just want to make sure I heard this correctly. So as of September 15th, our employees in our retail stores will now be on furlough for 6 months exactly.
Right.
So do I have to now bring them back, or do I have to provide proof that we're extending it due to the business?
So there's the requirement of it depends, right? It depends on the amount of employees who were put on furlough.
It's 10.
based on how big of a company?
We're 27 in New York, and in the UK, it's 100.
Okay. Let me see here.
Hi, Andrea. How are you?
Hey, Kim, how are you?
So, I mean, because you're dealing with such small numbers,
Mm-hmm.
you're not going to trigger warn, but because it is
Okay.
6 months, it's a good idea just to send out another communication to your employees. And if you're not planning on bringing them back right now,
Uh-huh.
going to extend their furloughs, it's a good idea to maybe touch base. I don't remember what your initial letter said in terms of time, but that's a good idea to look back at that initial letter, the furlough letter that you sent. And I know we worked with you on it, so I can look back at it as well. And see what, if you anticipated it being a certain duration and now it's more than that, then you want to communicate something with them. If you left it open ended, it's up to you.
Yeah, it was open ended, and there has been some talks that we're opening, but I'm not sure what is holding that up now. It's in our finance team, but the team is starting to get restless, and also the fact that the corporate employees have now come back and they haven't.
Mm.
So, yeah.
People are getting restless, and there's
Yep.
chatter of some people coming back and not others. It's a good opportunity to reach out to them and communicate with them, and we can totally help you with the proper method of communication.
Yeah. Okay.
But you wouldn't have warned things to worry about at least, so that's good.
Okay.
Yeah, thanks. That's a great question. Does anyone else have any questions for Victoria? Okay, well then I think we should move on to Lisa, who has some really interesting topics to discuss.
Thanks, Kim and Victoria. So I'm going to discuss COVID-19 liability waivers first. Some of our clients have been asking whether employers have been using a liability waiver that employees are either forced to sign or asked to sign if employees either express the desire to work in the office or travel or are made to by their employer, and whether this is something feasible to do or not, and more specifically, whether it would even help against potential claims of someone getting COVID as a result of working. So at a baseline, liability waivers can potentially be a very effective tool for avoiding personal injury lawsuits and potential liability. But liability waivers for pandemics and specifically for COVID-19 exposure, contraction, spread, are new, and they certainly haven't yet been interpreted by the courts in a large amount. But what the purpose of today is to share what we've been recommending. So as to employees at a baseline, we believe that requiring employees to enter into waivers would be not recommended, as in requiring employees to return to work and then requiring the waiver. Number one, they would likely not be enforceable as to actually waiving away the right to suing or bringing an action against the employer if they were to contract COVID. And that is so just because employers cannot waive away rights to creating a safe workspace for their workforce under OSHA, workers' compensation, and local COVID-19 orders, such as every Governor Cuomo endorsed COVID executive order, as well as our internal New York Department of Labor guidance, as well as U.S. Department of Labor guidance. This is all required steps that the state of New York, at least particular with New York and elsewhere, have said that their local employers need to be cognizant of. And of course, what I'm discussing now, I know that has been discussed in previous forums, so I won't get into that. But we, of course, know the strictures of New York Forward, and those are things that you cannot waive. So that's the baseline. But even practically speaking, asking employees to sign a waiver, certainly may not go over well with employees and make may make them fearful to return to the workplace when you do open. And, the question is, what would you do if someone didn't sign it? It would certainly be unlawful to fire them or take on an adverse action. And you've actually possibly made a protected whistleblower out of anyone who speaks out about that. So that's certainly not something that you want to take the risk in doing. And then actually asking for that waiver could also, in theory, increase the risk of a lawsuit, because a plaintiff's lawyer could argue that it's evidence that the employer is not taking the full responsibility for the safety of the workplace, and could even use that to argue for punitive damages. So, these are all recommendations. These are all considerations that build into our recommendation that, you would not want to make that a requirement. There may be limited circumstances where getting an assumption of risk waiver from third parties could be beneficial, something along the lines that it's not mandatory, but it would be for vendors and staffing agencies that are sending people in. But as a starting premise, a good alternative to any of that would just be a contractual agreement as to who is doing what and who is responsible for who, and potential indemnification language. For instance, if there's a staffing agency that's going to be sending in workers, an agreement that the staffing agency will get an insurance policy and list you, your entity, your employer, as an additional insured to cover for that risk. But you likely can't get that with guests or visitors, of course. So that would be where maybe a liability waiver would be designed to limit that liability for people entering in a business's premises to utilize its services. And in that, it would just be more recommended that you let them know as a disclosure what you've done, and make it a knowing assumption of risk, in that, you are doing all of these things, social distancing, whether you're requiring masks or not, available hand sanitizers. And the disclaimer, it would say the company cannot prevent you or your children from becoming exposed or contracting or spreading while utilizing the services, because it's simply not possible to prevent it. But if you choose to utilize the services, you're increasing your risk of contracting or spreading it. And that's really just kind of getting your ducks in a row to suggest that, the employee, the customer or the vendor was aware of everything that the employer did ahead of time and specifically assented to that. So the concern, of course, with all of this is that COVID-19 waivers in some jurisdictions could be held to be against public policy. New York State especially is particularly rigid with resisting liability waivers. They're closely scrutinized and generally disfavored in many capacities. So any waiver should be drafted with 3 key ideas in mind. Number one, the waiver must be clear and unambiguous. The fundamental requirement is that they're drafted in a manner that guarantees that customers or third parties understand the risks associated with the services, as well as the rights they intend to waive. Number 2, there's no waiver for intentional, reckless, or grossly negligent conduct, and most states will not enforce a liability waiver of such kind. And 3, waivers that are contrary to public policy are unconscionable and are not enforced. So even where they're unambiguous and clear, they could be deemed contrary to public policy and therefore unenforceable. So that brings us to the overall concern here, which is to date, there has been no legislation addressing general corporate or institutional liability for COVID-19 related injuries. There's some concern here, as it is unknown the extent to which state courts, at least in New York specifically, will enforce liability waivers under these circumstances, and whether a company can even rely on the use of a waiver to guarantee it will be enforceable for any business activity, and that is so because a company will be held to a certain standard of care concerning COVID, whether or not they utilize a waiver. And because of that, any waiver that you would ask someone to sign could be thought of as a contract of adhesion, which is just so void as to be against public policy as so that it is void, which would mean that you're asking someone to waive away rights that they should not have to waive away, because the employer should have that responsibility under that standard of care. And so there should be no reason why asking an employee for a waiver of this, or asking a individual for a waiver of this kind should be done in light of the fact that certain responsibilities are not waivable. And of course, state laws vary greatly concerning the enforceability of liability waivers, and a number of factors are specific to the circumstances of their use and the nature of the harm alleged. So, these are all open-ended questions right now. It's just not far enough down the stretch of this coming into the public consciousness of employers and individuals being asked to sign such things. So it's definitely something that it'll remain to be seen how the courts address this. But we're certain that it's coming, and it'll be a hot topic to watch. The next topic I will discuss is screening. And for those of you who joined the last forum, we covered this there. So I will try not to go into too much detail at the risk of being repetitive. But as we all know, New York State requires, as their reopening guidelines under New York Forward, that businesses must have a plan in place to protect employees and customers and consumers and make the physical workspace safe. And that includes in mandatory health screening practices. And that New York Forward has actually said that employers need to enact a continuous health screening process for individuals who enter the workplace, whether that be employees or third parties or customers. And as you know, that includes temperature checks, health questionnaires, contract tracing, and can be a mixture of any of those, and it is something that each employer has the ability to mold to their satisfaction, so to speak. But the one thing that I wanted to talk about here is that the question about COVID testing. And so, as we know that there's New York law requires an employer to pay for a medical examination if it's not covered by insurance, such that if an employee wants to get a test, then employer health plans should cover it with no cost sharing. But many employers have asked about routine testing of employees in conjunction with their return to work policies, which is a little bit different. And so the Department of Labor actually had issued FAQs relating to, this is the U.S. Department of Labor, issued FAQs relating to the COVID-19 testing mandates that actually came out in the federal FFCRA, which allow for employees to get tested with no cost sharing. But that guidance clarifies that testing that's conducted to screen for general workplace health and safety is not covered under the FFCRA mandate, such that if employers are going to take that extra step and they want to actually test their own employees, that's not contemplated in that federal language. So if employees are asked to be subjected to regular COVID testing, some employers have been asking, is that something that other employers are doing? Is that a good idea? Some other clients are saying, before anyone comes back, let's say if we want to have a mandatory testing every 2 weeks. Well, the EEOC put out guidance in their employer FAQ fact section as to whether employers can test their employees on that regular basis under the guise of simply returning to work. And the FAQs say that the testing must be job related and consistent with business necessity. So, this would be, if that was satisfied, then employers could require employees to be tested before returning to work or as a condition of continuing to work. There's, of course, issues there. Number one, you're probably going to get pushback from employees, as some believe that the test is uncomfortable. Employers, of course, are going to have to pay for that test and pay for the time that the employee spends commuting to the test. Number three, there's, of course, locations in this country where tests are still scarce. It could certainly come across as a little bit tone deaf to use up tests if the thought is that it's not actually preventing it, you're just doing it to be to go over and above other social distancing and COVID prevention measures. And then there's also, of course, the efficacy question. If an employee gets tested before coming to work on Monday and is cleared and then gets it middle of the week but continues coming in, you really can't prove a business justification for doing a test quicker than every 2 weeks, according to EOC guidance. So you really wouldn't be using that test in the best way possible if in that circumstance an employee could get it and still continue coming to work. So those are just a few, those are meant to just be like a few reasons why employers, may not actually go the route of doing a return to work COVID test other than the business plan measures they've already put in place for screening, which are required under New York Forward. And then the alternative to mandatory tests would actually be if employers don't want to reopen their office, but if employees do want to come in, well, they can tell them that employer must get tested. But that would actually possibly have the effect of deterring many people from coming into the office if that is actually the end goal that the employer had in mind. So it could kind of work both ways. If the employer doesn't actually want to have its employees returning to the office, if working remotely is working well for their team. And just as a bookend to this discussion, antibody testing is not contemplated under the EEOC FAQ guidelines. It's not job related or consistent with business necessity. So employees cannot be required to take one in order to return to work. I do see that we're about 5 minutes away from the end, so I'm going to announce the CLE code right now. It's SS as in Safer Shaw 0148. So again, that's SS 0148. So the last topic that I'm going to discuss is just other evolving liability issues for employers. Of course, the biggest concern for any employer in this context is workplace exposure and how people might redress that via lawsuits. Businesses should, of course, be aware that the state has already created avenues for individuals, including customers, to file complaints against a business for failing to comply with New York Forward guidance. I believe there's a hotline. You could do so online, and you can register complaints on working conditions with the New York Department of Labor. So that's already something that has opened up the channel of communication between employee and the overarching agencies with oversight on this, on New York Forward measures. But taking it one step further as to what individual employees could do without the interaction with the state, thinking about number one, personal injury claims. So personal injury claims on a theory of negligence, perhaps, meaning that a person or a business did not use the appropriate care. They would have to, of course, show that they would not have suffered the harm if the defendant had acted reasonably. These are cases that do not typically arise from contracting an infectious disease such as the flu. It's certainly going to be hard, to prove the precise source of exposure, but and as well as identifying a specific action that the employer took that showed a lack of reasonable care. But for all the reasons we discussed earlier with the liability waivers, there are going to be ways, of course, that plaintiffs' attorneys are probably going to craft the measures that employers have taken and use that to their advantage. So that's something you just want to be aware of, especially with a negligence suit like that. Generally speaking, with personal injury at a baseline that's not negligence related, that would be, in our interpretation of current existing law, preempted by workers' compensation. Of course, workers' compensation presents in many states a no-fault insurance compensation scheme for workplace injuries for court-based tort remedies. So workers would receive workers' compensation benefits, and they would be barred otherwise from suing in tort. So here, an employee, if they were suing for an injury in the workplace, they would likely not have a personal injury claim based on contracting COVID. It would be a workers' compensation claim. And there's the benefit to having this type of claim part of the workers' compensation scheme is that workers' compensation benefits are capped. There's a cap to liability rather than it being a common law negligence claim award payout at, as a jury verdict or a judgment as a matter of law in a court, which could exceed workers' compensation benefits greatly. I believe right now in 2020, Workers' compensation benefits are capped always at the 2/3 of the New York State average weekly wage. So I think that's $966 right now, but I'll check that going into 2021, and I would recommend checking that as well, just to get a sense as to, the difference between what a damages award you could be looking at versus, of course, workers' comp. And the New York's Workers' Comp Board actually issued a Q&A fact sheet about this with some helpful questions and answers. So one question was someone asking in the hypothetical, can I receive workers' compensation benefits if I get COVID while working? And the board actually answered yes, depending on the facts, you may. Employers must carry workers' compensation insurance to pay benefits to workers who are made ill or injured due to their employment. This is known as a work-related illness or injury. And it cites that in previous outbreaks like tuberculosis and asbestos, the board has always risen to meet the needs of injured workers across the state. COVID is no exception. So that's a pretty direct implication. That's a pretty correct statement that leaves no room for equivocation that they are considering that workers' comp covers this. So that would be one scheme, as I just discussed. So the others, I would just quickly, I'm going to touch on, of course, failure to provide a safe work environment. Again, this would be a negligence claim, but it could also be brought under OSHA. We've seen some age and disability discrimination claims, especially, older workers that might be denied accommodation from home, or an older worker, for instance, forced out of their job because of an employer's concern. Those were cases that were part of the early wave of litigation. Of course, we've seen numerous leave lawsuit claims under FMLA and Families First Coronavirus Response Act. We anticipate that there's going to be some retaliation and whistleblower claims, which are typically asserted in reference to an employee's termination. We've already seen some of those appear in the early COVID-19 related cases, about an employee terminated for complaining about workplace safety or reporting it outside of just the workspace. And then, no surprise, the usual litany of wage and hour, class and collective actions has continued, and we expect will continue. And we certainly expect that there could be some off the clock claims on the horizon, possibly in a class form, that suggests that those expanded sanitation and hygiene protocol screening time is compensable time, and that the employees should be compensated for it. So yeah, that's just kind of a brief snapshot of the other evolving liabilities. Of course, that all these laws have an interrelated ability to present a risk here. But of course, we deal with this all the time in non-COVID related matters. So we are here to help if and when your business is faced with any one of these issues. So with that, I'll throw it back to Kim.
Great. Thanks, Lisa. Does anybody have any questions? Okay. Well, if nobody has questions that they can think of right now, at any later point, you are more than welcome to reach out and email either Victoria, Lisa, or myself with any of your questions. And thank you again for joining us today. And we look forward to seeing you at a future HR forum. Thanks.
Thank you. Bye-bye.
Bye-bye.